Okay, let's get to the content. Welcome to Can They Do That? The U.S. Constitution in Today's America. Very glad you're here today. I hope you'll find this topic as interesting as I do, and I hope you find at least my presentation will keep a majority of you awake. Our website, in which we have content and notes from today's class, is available at tinyurl.com/OLLI-CSUF. And you'll find a variety of notes there, including some of the cases we talk about today. This is planned as a 10-class arc. We started last semester. We had three classes. We'll do 4 now, and we hope to do another 3 next semester. And then we'll see where we'll go from here. And in the first semester, we talked about the Constitution Convention and the principles of the Constitutions. Article 1, Congress. Article 2, the President. Today, we'll do a little more history. We'll review some of the constitutional principles. And we'll go in depth in Article 3, having to do with the judicial branch. Later on in this semester, we'll complete the remaining articles of the Constitution, and then we'll go into the amendments. But I'm going to cluster the amendments in a way. One, those amendments that broaden the right to vote or participate in our political system, the slavery era amendments or the post-slavery era amendments, constitutional corrections, and the prohibition amendments, as well as the suffrage amendments. And we'll talk about the enduring controversies about constitutional interpretation. Some things are very clear in the Constitution, like you need to be 35 years old to run for president and be a native-born American. But then you had incidents like John McCain being born in the Canal Zone to American parents. You had Ted Cruz with dual citizenship. You had the debate for a while, the so-called birther debate about President Obama citizenship. So some things, even when they appear to be clear, are not clear once you have advocates making the case about how provisions of the Constitution should be interpreted. And in each class, I want to talk about some just the highlights and some in more details. Today will just be the highlights on the Constitution in the news, because the Constitution is not abstract. The Constitution is something that is affecting our democracy, our republic, almost every day in its interpretation and implementation. And in the fall semester, we'll have some more guest lecturers. I thought the faculty is mostly off campus now. It would be good to come back to them once they get back on campus in large numbers. Primary sources are these. As you can tell, the National Constitution Center is right at the top of the list. I also educate myself for each class by listening to a number of podcasts. And these are the ones I particularly enjoy. The We the People is by the National Constitution Center, and they put out a podcast just about every week, an hour and 15 minutes, usually one of their conferences they do at the National Constitution Center. The current one is on reproductive rights. They had a 2-parter on that. And of course, I encourage you to look at more than just the sources and the content I present here. And I try to put on the website some reinforcing content and some contrasting content. For example, this morning I added something from the Federalist Society, which is admittedly has a conservative reading of the Constitution about the whole issue of judicial interpretation of the Constitution. Today, Constitution in the News, review some constitutional principle very quickly. Then we'll go into detail on the judiciary, and we'll talk about the Supreme Court up through the Civil War. And then we'll talk about the controversy regarding judicial review. And we'll end with a couple of topics, short topics. Okay, let's talk about the Constitution in the news. The Supreme Court last week seemed to be in no particular hurry to deal with the issue of reproductive rights, major restrictions on abortion, probably until the next election is over. It's they upheld only a small part of an Indiana law, and they seem to want the issues to work their way up through the circuits, courts of appeal, and in some cases, several circuit courts before they'll want to take it. Under the system currently in place by the Supreme Court, you need 4 of the 9 justices to agree to hear a case. So there's no doubt there are 4 progressive to moderate justices on one side of the court, and there's no doubt there's 4 conservative justices on the other side of the court, probably 5 with Chief Justice Roberts. So when it doesn't get 4, you wonder why it doesn't get 4. Well, this is probably the why, and you can't see this, but let me tell you what you can't see. This is a map that the website 538.com did about the abortion restrictions in various states of the nation. And lots of states like California, there's no listing. While there are some abortion restrictions set forth in furtherance of the Roe versus Wade decision about when an abortion can occur, the more restrictive laws are the ones impacted. If you take away a national standard and you rely upon the states, you can see that will be a whole variety of consequences. And I think the court is not in a hurry to get to that point. We'll see. We also saw on the issue of the investigation by Special Counsel Robert Mueller that in his public statement last week, he cited the Constitution. He said that the Attorney General opinion, or actually the U.S. Department of Justice opinion on whether or not a sitting president can be indicted it is based upon the Constitution. And had these not precise comments that basically said there's another way to handle this without using the impeachment word. The opinion says the Constitution requires a process other than the criminal justice system to formally accuse a sitting president of wrongdoing. Yes?
Where is it in the Constitution that says you cannot indict a sitting president?
It's an the question is, where in the Constitution does it say it? It's an interpretation of the Constitution by the Office of I forget what it's called, Office of Legal Counsel, Office of Legal Counsel in the Justice Department, that is in effect the master attorney on issues of law in the federal system, just as the Attorney General in California interprets the California laws. We also had a judge in California blocking the administration from using funds, quote, not appropriated by Congress to build a wall. And then we had a judge yesterday say, hey, you can do that. So the 2 different federal district judges, one I think appointed by President Obama and the one yesterday by President Trump, deciding different ways. And I put the more recent one, the one by the judge yesterday. I have that on the website. I have the full opinion why. And basically what he said was that one house of Congress didn't have the right to sue on the use of federal money, though he said it was a very close call. And he said since other courts are dealing with this issue, he didn't have to weigh in. But it starts with, few ideas are more central to the American political tradition than the doctrine of separation of powers. We'll talk about that in a moment. Then we had a different judge, federal judge, upholds the House panel subpoena for Trump financial records, citing, again, the Constitution. And then the House Judiciary Committee chair a few weeks ago said we're in a constitutional crisis. Well, the National Constitution Center actually had a panel on what is a constitutional crisis. And here's what I learned. According to the scholars, there's really only two types, though they say it's not binary. You can have degrees of crises. The first type is operational, and that is when the Constitution doesn't solve an existential issue facing the nation. Any examples you can think of? Oh yes, the issues that led up to the Civil War. The Constitution didn't yield a solution to that crisis. In large measure, you could argue it helped create the crisis in a Supreme Court decision we'll talk about later on today. Second, you can get into a constitutional crisis when the major players or branches of government do actions that are not in fidelity with the Constitution. For example, when Andrew Jackson, President Andrew Jackson, some of you may remember him. I thought he was, kind of a fun guy. You don't want to get in an argument with him. He was a dueler. But President Jackson, after the Supreme Court ruled that an action regarding the Cherokee Nation was invalid, President Jackson said, well, let the Chief Justice enforce it. And it wasn't enforced. We'll find out that President Lincoln said the same thing. Campaigned on not enforcing a Supreme Court decision, and in his first inaugural address said he wouldn't. And then had Congress pass laws as if the decision had no force in law. Fidelity crises. However, rebuffing a democratic norm is not a constitutional crisis. Just because historically Congress and the president or the courts and one of the branches historically followed it doesn't necessarily put you in a constitutional crisis. So that, to Chairman, the Judiciary Committee Chairman, about the White House resisting the subpoenas, probably it's not a constitutional crisis because the next stage is Congress going, as they probably will, and going to the courts and asking the courts to enforce it. Even Nixon avoided a constitutional crisis when the Supreme Court said he had to turn over the tapes by producing the tapes. If he had said no, or if he took his then Secretary of Treasury suggestion, Secretary Connolly, burning them in response, it would have been a constitutional crisis. We have even in the issue of homeless constitutional issues being raised. The city, San Clemente says, there's not, constitutional obligations for cities to destroy themselves through dealing with the homeless issue. However, one of our guest speakers last semester, Professor Tom Campbell, who was a guest speaker via videotape, took a more reasoned approach in an article in the Orange County Register, in which he pointed out courts aren't to blame for the rise in the homeless population's problems. And basically he said there that under our system and under the Ninth Circuit Court decisions, it's not a crime to be poor in America. It's not a crime to be homeless in America. Government can regulate where people set up habitation, but can't prohibit habitation areas existing in a community for poor people. So if you have a place where they can voluntarily go to, you can restrict or ban people sleeping on the sidewalks. You don't have to force them into the places that you have provided them. They just give up their constitutional right to sleep on the sidewalk if you do. Interesting argument. Again, Constitution, the news, people disagreeing. Of course, it's easy when you have a constitution. Think about the United Kingdom. The United Kingdom doesn't have a formal constitution, just an understanding. Just a set of norms and laws and oftentimes pronouncements by the Speaker of the House of Commons. Britain, from the Economist magazine article this week, Britain often is said to have an unwritten constitution. Many Britons have blithely taken this to mean something of a badge of merit, one bestowed upon us by Providence. Many of there are statutes such as the Bill of Rights, 1689, rub up against the Human Rights Act of 1998. And as it goes through this, it is a murky situation when you don't have a constitution to squabble about, because it could be almost anything. You know, Scotland may want to go away. Northern Ireland may want to break off from the UK. There's no process. There's no constitution that suggests how you might handle that issue. So let's review some constitutional principles from last semester. This will be a quick review. One, in coming up with a constitution after the end of the Revolutionary War and the Articles of Confederation, a majority of those who made the decisions, which were both the framers of the Constitution and those who were in the ratifying conventions, wanted a government stronger than a union of sovereign states, which existed during the Revolution and after the Revolution. But not too powerful. Don't want completely sovereign states, but not a national government that is too powerful. But definitely not a monarchy. Though I think some would like to have a monarchy at times. But a government designed to prevent a tyranny of the few. They were also afraid of democracy and how that can end, how war fever or a majority against a minority might end with destroying the system. Madison was particularly vocal on this. So what they came up with was a mixed system of government, featuring checks and balances and power sharing. Not to go into Aristotle a whole lot, but that was not unlike what Aristotle suggested thousands of years earlier, in which he talked about the various forms of government and which forms might work best and what happens when that form of government, how that form of government breaks down. The one ruler system works well and the monarchy works well, but it can deteriorate into a tyranny depending upon who becomes the monarch. Think of Game of Thrones. or a few rulers in which you have an aristocracy, either an economic aristocracy or one by birthright aristocracy, and how that can also devolve into a plutocracy or an oligarchy. Or too many rulers, a direct democracy in which it can spin out of control in type of mob rule or anarchy. So the framers came up with a mixed form of government. A federal government consisting of limited central government, of delegated and enumerated powers. And states, no longer sovereign, with general governmental powers. That is, the state's powers didn't have to be enumerated to exist. They could do what is normally called either general governmental powers or plenary powers or police powers. They all mean about the same things. They can pass and enforce laws that promote the health and welfare and safety of its population. They didn't need a grant of authority to do that. And the system was based upon the Republican principle that supreme power should be held by the people and their representatives. So the people and the representatives have the supreme power, not the states, not the federal government, through a constitution. And that is enshrined in the Constitution, not in the initial document, but in the amendments that were passed by the first Congress of the United States and ratified within a year of its submittal, in the 9th Amendment and the 10th Amendment. The 9th Amendment, that sets forth powers not otherwise enumerated to another form of government to the people, or to the 10th Amendment that says similar things regarding the states. A key constitutional principle was checks and balances on government power through division of authority. A chief executive, at least initially selected by the states through an electoral college system for a fixed term. Now, there was no term limit, but there was a fixed term of 4 years. Something you didn't have for the King of England or the King of France. And subject to congressional removal, not by assassination, but by political process. A separation of powers among 3 branches of the central government, between the legislative branch and the judicial branch and the executive branch, each checking and balancing each other, each with functional authority in an area, but that functional authority can be checked. The Supreme Court is appointed by the executive, but is confirmed by the Senate. Now remember, the Senate was originally designed to really represent the states. So really kind of so you had a check and balance there. But the House of Representatives is the only body that can initiate taxation, representing the people. Or at least the enfranchised people at that time. So in a way, the Aristotle model of how you set up government is followed in the Constitution. You have something that looks a little bit like a monarch, that is a single ruler, the head of the executive department, the president. You had, a few rulers in terms of the Senate appointed by state legislatures, not by governors, but by state legislatures. And many rulers through the House of Representatives. Okay, that's a quick overview. Let's go to the judicial branch. Article 3. Article 1, the Congress. Every member of Congress likes to say, we're the first article. President never says, I'm the second article. I'm commander-in-chief. Article 3, the judiciary. The one that was famously called by Alexander Hamilton in the Federalist paper, not necessarily in the play, as the least dangerous form because it has no army, has no power to tax, the least dangerous form. Okay, let's start. I'll go from paraphrase to direct, and I'm going to take you through in detail, but hopefully not excruciating detail. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may time to time ordain and establish. So, Constitution is sets up the Supreme Court, but then says, hey, Congress can say, if you want an appellate court, if you want a district court, if you want a bankruptcy court, you want one dealing with tax law, you want to do one on military justice, that will be a congressional power. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior for life. Then put the for life in there, but for life. Now that's a big frickin' thing. Frickin' is a legal term. That's a big frickin' thing. Once appointed, you're there for good behavior. What's good behavior? Constitutional interpretation. And shall receive for their services a compensation which shall not be diminished during their continuance in office. What might happen otherwise? If you don't like a decision, you cut off their pay. Right? No, we can't do that. What is the jurisdiction of the court? What cases can they hear? Well, they can hear cases arising under this Constitution and the statutes and laws of the United States and treaties made. Their jurisdiction is about laws and actions affecting ambassadors, other public ministers and consuls, basically foreign entities, of the admiralty and maritime, of the sea law, which the United States shall be a party to. So when the United States sues, it will be under the jurisdiction of the court system, of the federal system, not of the state system. That's an important provision. Judicial power shall extend to controversies between a state and citizens of different states. So California can't sue Nevada and have the case held and decided by a California judge, or vice versa. A citizen of California can sue a citizen of Georgia, and it would be in the federal court. Where in the federal court is decided by federal court rules. Citizens of the same state claiming land under grants of different states. That was particularly a big issue 200 years ago and 100 years ago, less so now. A state or the citizens thereof and foreign states' citizens are subject. So if you want to sue Afghanistan in California, you don't go to the Superior Court. You go to the Federal District Court and do that. Okay, I think most of those are logical. Then it turned out to be a key provision of the Constitution. Doesn't seem that way at first. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction, meaning the case is heard by them first, not by any other case, any other court. By the way, that never happens. What they do, or at least in recent times, they appoint someone else to do a hearing, and they just take the transcript and decide. But someone they appoint, the court appoints. In all other cases, the Supreme Court shall have appellate jurisdiction, both as to law and facts, and such exceptions and under such regulations as Congress shall make. So in all other cases, some other court heard something, and now it comes to them. But what court hears it is determined by regulations as Congress shall make laws. Jury trials. And it's important to note, until we get to the 14th Amendment later on, not today, the trial of all federal crimes, I put in federal, but this is how it's interpreted, except in cases of impeachment, shall be by jury. And such trial shall be held in the state where said crime shall be committed, shall have been committed. But when committed within any state, the trial shall be at such place or places as the Congress may by law have directed. So it sets up a lot of places where the Congress can come in and establish rules. Treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. You hear the term, so-and-so is committing treason. Well, this is a very, in the British system and in other systems of government at the time of the Constitution, speaking ill against the king, sleeping with the queen, would be treason. Treason would be considered treason. That doesn't fit this definition, unless it's an enemy of yours. No person shall be convicted of treason unless on the testimony of two witnesses for the same act or on confession in open court. So another abuse of the English system and the monarchical rule in other nation is they bring someone in and say, hey, that person did this and that's treason. Now do what you want with them. No, you have to have at least two people. Or a confession. You can't say, well, that person confessed. He's dead now, but he confessed. And so, no, you can't do that. And the Congress, not the executive, shall decide on what is the punishment of treason. But no attainder of treason. That is when you don't have a trial and you just declare a decision. An attainder. A bill of attainder in a legislative branch is that you'd find this person guilty just by whether or not there was enough votes in the legislative chamber and what they sentences without any appeal rights. But no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Does anyone know what corruption of blood is? Okay, I got a definition. Corruption of blood. The disability of any posterity of the attained person to claim any inheritance either as heir to him or to any ancestor above him. So think of the English system when you have this aristocracy. They have Downton Abbey. And the person, what's the head of the Downton Abbey? What's the lead character? Who? Lord Grantham. Well, let's say he was tried for treason. They found him guilty. You couldn't just take away that from his heirs. You couldn't say you can't have Downton Abbey anymore. Because we're only punishing him, not his posterities. So you want to put your Downton Abbey into a blind trust for someone else before you commit treason, I guess. Yes.
And the last sentence of that, it says it's set up during the life of a person.
Yes, the punishment could be actually that it may be taking away Downton Abbey, or at least during the good times of the year. So they could do it to him. They can't do it to the posterity, or things that his posterity, that person's posterity, might inherit from ancestors above him, in which you basically wipe out that inheritance line altogether. Again, another common feature of the English system at that time.
How do they justify taking away Arlington from the Lee family?
The question, what was the justification taking away Arlington from the Lee family? I don't know. I'm sure there was a court decision on that. Let's talk about impeachment. Impeachment is essentially not in Article 3. It's in Article 1 and Article 2, but let's talk a little bit about impeachment. The President, Vice President, and all civil officers in the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. That includes judges, includes Supreme Court judges, and the three categories, two of which are easy to understand, and the third of which has befuddled people for ever since the Constitution was adopted. Treason and bribery, good reasons. High crimes and misdemeanors. There is context for what were high crimes and misdemeanors at the time of the Constitution, but some of them are archaic now. So that what are, and as we had Professor Campbell tell us, it's essentially what the Congress by the House by a majority vote and Congress by 2/3 vote decides what it is. It's as close as a bill of attainder as we have. The Senate shall have sole power to try all impeachments. So the House impeaches, thinks indict. When the President of the United States is tried, however, the Chief Justice, so I put it in this section too, shall preside. So you got all three branches in play then at that point. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any offer, honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So you can remove them from office and prevent that person from taking another job or position of authority with the federal government. This is the federal government. And you can use the criminal statutes. That's an important part of the Constitution. That's essentially Article 3. Where in Article 3 is the provision that the justices can decide to strike down an act of Congress? Where is in Article 3 the provision where a court can stop the executive branch, the president, from taking an action that they believe is unconstitutional? There were scholars who said, both contemporaneous with the Constitution and the years since, that all three branches can declare acts as unconstitutional. President Theodore Roosevelt, when he was out of power, but when he was running on the bull moose ticket to get it back in as president, came up with the idea of judicial referendum, that the people should have the right to strike down decisions of the court. You just put it on the ballot, and you do it. So where does that come from? And let's talk about judicial review, and I'm influenced in my presentation by this interesting course that was suggested to me that was being done at Princeton University, online course, free, still going. You can sign up for it, it's free. It's part of edX. If you've ever done edX, edX is a national consortium established by an MIT professor at one point to provide materials of a college, university level to anyone who wants to view it. You have to sign up for it, and we'll go through the edX thing a little bit later on. But so I'm going to use some concepts I picked up in that class. So let's talk. Marshall declared that the Congress by having the Supreme Court consider these types of cases violated the provision of the Constitution that set forth what was its original jurisdiction versus its appellate jurisdiction, and struck it down because of that. But judicial review is not an expressed or enumerated power granted in the Constitution, though Hamilton argued that in fact it is part of the Constitution. He argued that in one of the Federalist Papers that he addressed to the people of New York in the ratification convention in New York on the Constitution. It is arguably the judiciary's greatest power. You look in the lobby of the Supreme Court of the United States, and there is the Marbury versus Madison ruling. As set forth by John Marshall. It is emphatically the province and duty of the Judicial Department to say what the law is. Now, so they have this power. They might use it a lot. No, they didn't use it again for 54 years. For 54 years. But they had established a precedent for this. Unfortunately, the case they next used it for led directly to the Civil War. It was a case called Dred Scott, a male slave, versus Stanford. The Supreme Court ruled that Americans of African descent, whether free or slave, were not American citizens and could not sue in federal court. And this was a case over several years to get to the Supreme Court. More on this. And it struck down the Missouri Compromise, that statute that was used to admit new states into the Union above the latitude of Missouri, in which states admitted above it would be free states. The states below would allow slavery as a matter of government policy. It struck down the Missouri Compromise. Lincoln, running for president, denounced the decision before and during his presidency. He in Congress, once he became president, ignored the Dred Scott decision and passed laws. One is banning slavery in areas in the territory of the United States that were not yet states. He also, during his first inauguration, said that that was a wrong ruling and he wasn't going to enforce it. Some narrow interpretation of judicial power says the right of judicial power should only be interpreted narrowly, only when Congress passes a law and the president signs it that would require the judicial branch to do an unconstitutional act, should they act. Not when Congress does an unconstitutional act or when the president does it. Some, to this day, still argue that point. And it wasn't until 1958 in which the power of judicial review was really set forth in a Supreme Court decision. Not until 1954 in the Supreme Court in the Cooper versus Aaron case. Okay, let's talk a little bit more about the power of judicial review. So, Was that a good thing, do you think? The power of judicial review? The power to allow the Supreme Court, and why wasn't it an express power? Why wasn't a government a limited and enumerated powers? Why didn't you say what happens when one branch does something that is unconstitutional? Maybe because they were influenced by the British model. You could argue that the British model, that good actors wouldn't do that. There were a code of conduct that you would not do things that was so egregious to the preservation of the Republic. Well, that was not the one chosen by the Chief Justice. As a matter of fact, the Chief Justice, John Marshall, remember, he was appointed to the Supreme Court and held the office of Associate and then later Chief Justice while he was still Secretary of State. He had a foot in each branch of government. And in the Marbury versus Madison case, it was his brother. It could have been him. He could have had a busy night that night and forgot to deliver that last one to that guy that needed the job, right? Mr. Marbury apparently hadn't found a job in a year and a half. And still need one of those federal government jobs. It could have been as simple as that. So did John Marshall, who was a captain in the Revolutionary War, was a diplomat, was one of the 3 American ministers to France during the famous XYZ affair. Matter of fact, during the XY, in which the French demanded the payment of bribes before they would convey a message from the government of the United States to the French monarchy. He was one of the 3 he was bribed. Even worse, he was the whistleblower. He was the ones that said, hey, they did this, impugning the ability of the United States to have normal diplomatic intercourse with France, that you wouldn't have to bribe someone to do that. He was actively on the lines during the Revolutionary War. He was wounded during the Revolutionary War. He was one of the major advocates in the Virginia Ratification Convention on the Constitution and argued for the Constitution. So he was hardly, someone that was beyond the arguments of the day. He was very much part of it. Now, I think in large measure that John Marshall figured out that the way this played out could be very good. Instead of being backed into the corner, in effect, Jefferson and Madison backed him and the court into a corner, but he could play the chess game. He saw the board that they didn't see a board. What if you rendered an opinion that said, in terms of its actual implementation, that, yeah, this guy doesn't get to be justice of the peace? Got a problem with that? You didn't want him. You would almost have to change your position. No, now we want to appoint this guy. But they weren't facile enough to make that argument because they never thought they would come out with that. The Federalists said, hey, this is why we have federal judges on the bench, is to stop the excesses of this new Democratic Republicans, as they were called at that time, party. But instead, the Congress, and Madison should have known better, put together how the jurisdiction issue on the judicial appointments in the District of Columbia, or what became the District of Columbia. So that power. Now, there is really no force that would probably lead to the abandonment of the power of judicial review. It's so much part of our system now. But it was not designed into it. Even though you can cite Hamilton, and I have his Federalist paper on our website. I encourage you to read it. But I also have the Federalist Society that takes a different view. Video also on the website to see the, yes, judicial review, but it should be very limited. And that the judiciary, and we'll see this as we go through the Constitution, has often been at odds with the political movements of the time. Struck down many of the initial laws of the New Deal after during the Depression. Struck them down until President Roosevelt tried to increase the size of the Supreme Court and put an age limit on the justices. And couldn't get that through a Democratic Party-controlled Congress because the democratic norms prevented that. Nothing in the Constitution. The size of the Supreme Court is set forth by Congress or by statute, meaning Congress initiates it, the president needs to sign it. It's not by, now if you said 0, that would clearly be unconstitutional. Would one judge be unconstitutional? I don't know. Maybe. Would 20 judges be too many? I don't know. We have the Ninth Circuit Court of Appeal with how many judges? 28, 40 judges, in which they, meet in groups of 3, but they can decide cases, that is the entire court. So that was a very important power. Okay, some other stuff. These are endnotes, but we'll spend a few minutes getting through them. We'll be back in 2 weeks. We return on June 18th. We'll be talking about the rest of the articles. We'll be talking about the court through the Civil War and major cases occurring. One of the things on the Dred Scott decision that wasn't in the video was that President Buchanan, who generally is listed at the bottom of the hierarchy of American president, bottom of the list, talk to the Chief Justice about doing just that. He said, you got to, I don't want the South to secede. I don't mind slavery that much. You got to stop the abolitionists from tearing this country aside. Well, that didn't happen. Well, that happened, but what happened was that the South, by seceding, led a general discussion on whether or not there would be abolition to whether or not it was unconstitutional to withdraw from the nation. You can get a copy of the Constitution in a very convenient way. Hold that up. Where are you? Yeah. By just writing into this website, and you'll get a hard copy free from Hillsdale College. I don't think you'll be on a forever fundraising list if you do. And I have this listed on the website. You just fill out the form, you'll get one. It'll take a couple of weeks. Let's talk about this online course. Because I would imagine you all are at various degrees of interest in this topic. Perhaps, hopefully a little more after this lecture today, maybe a little less after this lecture today. But if you really want to delve into the topic of constitutional interpretation, I've done now about 15 hours of this edX class, and it's fascinating. Let me give you a little bit of a preview on it.
We the people, the American people, we've long venerated our Constitution. We credit its genius with the unprecedented success of our Republican democracy. We're in awe of the wisdom and the prescience of those men affectionately known as the Founding Fathers, who wrote the document and won its ratification. And yet Americans are divided about fundamental questions of what the Constitution actually means, what it requires, what it forbids, how it should be interpreted. Some critics argue that it's out of date. Richard Posner, a famous judge, quipped, for instance, 18th century guys, however smart, could not foresee the culture, technology, and so forth of the 21st century. So are these critics right? Is the Constitution too vague or too dated to provide guidance? I think not. If we take the trouble to understand the provisions in the Constitution in their textual, structural, and historical context, and interpret them in an analytically rigorous way, we'll find that they do provide principles and norms that are relevant to our civic life today. In this course, we explore competing theories of and approaches to constitutional interpretation. We ask, for instance, is the intent of the Constitution's framers and ratifiers relevant to how we interpret its provisions today? If so, what counts as their intent? What are the scope and limits of judicial review? That is, the power of the courts to strike down legislation that, in the opinion of the judges, violates constitutional rights or other constitutional provisions. If we accept judicial review, does that mean the judges always have the final say in disputed questions of what the Constitution means and requires? I hope you'll join me as we examine these and other questions related to our Constitution.
So how do you do that? This kind of sounds like an infomercial now, and I don't intend to. It is free, so, and it is a Princeton course. And it has 6 core topics and I believe 5 special topics, each of which is about an hour and 15-minute lecture. But more than the lecture, it's readings, it's the actual cases, and it's a discussion group that you go on. You can be in the discussion group for a minute or all day long, in which it's narrated by other professors and at Princeton University. And each has learning goals and as I said, a variety of and definitions of concepts to help you through it. And you can stop. You can stop at any time, and it has a running transcript, so that you can. And every 20 minutes or so, there's a quiz. Every 20 minutes, there's a quiz. The professor kind of stops for a second, and you're to the quiz. Now, but it's an open book quiz. And Google's always good, helping to find the answer. I could have read that case, or I could Google the finding. Anyway, I have the information on our website. But the live, that is the discussion groups and all the other stuff, is until towards the end of this month. But then it's archived and it's available for as long as the archive exists at edX. Okay, let me close on this final topic. This is an issue of academia. And this is an issue in which good people will disagree. And this is, how much effort should a public institution such as ours here at Cal State Fullerton or the other CSUs place on civic education as a requirement for graduation with a bachelor's degree? And I think the direction is it should be less, not more, is what many of the academic officials are arguing. And as I said, people can disagree, just as they disagree on the Constitution interpretation. But my bias is this democracy or this representative republic, more precise definition, based on democratic concepts and democratic norms, is best served when those that are governed know the system and know that not only their rights to participate, but their obligations to participate. Matter of fact, that was one of the arguments in the Federalist Papers, was that, and that was almost an argument every time suffrage was extended. Suffrage was extended to people of lesser property, and then to no property, and then just to any free, male, white male. And then it was extended and extended and extended. That every time it was extended, part of the argument was that now you have a greater opportunity by those who are governed by our system to participate, and through participation become buy into the system and how they are governed. Yet, in trying to get people through our system of education within at least 6 years for what used to be would consider a 4-year program, that we have bottlenecks. And one of the bottlenecks has been looked at as some of the humanities courses. Now, why doesn't an engineer need to know about the Constitution? Why does a nurse need to know about the Constitution? I mean, there's not like there's healthcare issues under debate. There's not. What would someone in the business college need to know about the history and our constitutional system?
That's easy to answer. The same reason a certain level of knowledge is required before you can practice medicine, before you can practice law, before you can vote.
Amen. And I would add to that, before you have children and before you get married. And before you try to teach an OLLI course, there should be at least some level of knowledge or interest in the topic. So anyway, I put that out to you as a special topic of my own. And I think that is also in our K-12 system too. I always thought, I do think, I guess I never changed, that when I took, the civics, and I learned about the Constitution, how many amendments there were at that time, and which number was to which one. It had no significance to me. It was rote memorization. It wasn't trying to explore the fundamental concepts of how we ended up, and some would say, hey, that was beyond our intellectual level or interest at the time. So why do we teach it at that level? So that's my plaintive little cry here. But part of the democratic principles of why this republic would work, according to James Madison and some of the Federalist Papers, is that it will encourage people to become involved in the welfare of the republic and be willing to fight to their death to defend it. Remember, according to some contemporary history, only 16% of Americans actually participated in the revolution. Only 16% of Americans. Some call the Revolutionary War the first Civil War, because there was as many, or perhaps more, on the stay with Britain side than to become a free government. The difference was that who we call the Patriots, who I believe made the right decision, the Patriots controlled the government. Every colonial government was controlled by those who wanted revolution. Every one the year before 1776. Hardly a precedent for that in which the revolutionaries were the one who controlled the government. Anyway, I had a hand up. and then I'll adjourn. Rich?
Mike, I don't have a problem with having awareness or history, but it should be mandated for anybody running for elective office to have at least a year of history. That's a prerequisite.
I think Speaker Pelosi was reported to have said in a Democratic caucus, what was it, yesterday? Yesterday, that, you know, I've talked to a lot of my constituents and to a lot of smart people in the last couple of weeks. And people don't know the difference between impeachment and removal. Between impeachment and removal. Some believe if the House impeaches, the president is automatically removed. And, you know, these are people who, constituents, smart people, interest groups, contributors, however you want to call that.
I think what's really necessary is an interdisciplinary course.
Yes.
That includes historians and political scientists and maybe a sociologist.
Sociologists, economists, I mean a whole lot of the scientists too. The scientists. Anyway, our upcoming classes won't have the sermon at the end. And we'll use today is somewhat of a template for the most of the class. We'll use a combination of some videos and some PowerPoints to go through these things. We got a whole lot of Constitution still to go through, let alone cases and the Constitution today, America. Thank you for coming.